All right, good morning. Welcome to the 294th District Court. My name is Judge Chris Martin. I'm going to call this morning's criminal docket. When I call your name, please say present or here and raise your hand so I can mark you as present. Wayne Dylan Dean.
Here.
Randy Lee Dobbins. Mr. Dobbins supposed to be here for a sanctions hearing, I believe. Jeremy Estridge. Amber Lansdale.
Present.
Robert Lopez. Robert Daniel Lopez. Randy McElroy. Randy Lee Shane McElroy. Matswana Malongo. Matswana Malongo.
Still got strong, Judge. Not going straight now.
Randy Young. Chase Enochs. Ashley Smith. Audrey Andrews. Charles Bennett. Savannah Cooksey.
Judge, one of the things.
Jonathan Curtis.
Here.
David Dixon.
Here.
Bobby Evans. Bobby Lynn Evans. Juan Gonzalez. Juan Jose Gonzalez. Garrett Joslin. Noe Limon.
Judge, he's coming from Dallas.
Julie McClellan.
Judge State following motion to dismiss. She's in federal custody on federal charges.
All right, court will grant the state's motion to dismiss. Christopher Nash. Jennifer Rollins.
Here.
Javier Zarate.
Here.
Tiffany Cooey. Amber Crisp.
Just state that text message that she is.
Who is that text from? Carlos Hernandez. Carlos Jerry Hernandez.
Nothing in the hall.
He's here. Mr. White's on paper.
Okay. Joseph Rushing.
Here.
Landon Watson. Landon J. Watson. Is there anyone whose name I've not called? All right, counsel, do we have anyone that's ready? Ms. Thompson, you ready?
Miss Curry,
Ms. Cooey. This is CR 22-208, State versus Tiffany Nicole Cooey, set for pretrial. And I believe Ms. Cooey, you've also requested appointment of a different court-appointed attorney. Is that correct?
Yes, sir.
Okay, go ahead, Ms. Thompson.
Your pre-trial has been filed, and we don't have any matters to be heard this morning.
Okay. With regards to Ms. Cooey's request for a different attorney, have you reviewed that?
I didn't receive any notice of that, no.
Okay. Ms. Tabraham, do we have a copy of what Ms. Cooey put in writing? It's, you're saying it's up here. All right, so go ahead and have a seat. I'm gonna call you back up in a minute. We're gonna give Ms. Thompson a copy of that so that she can review it. Spain, did you say you're ready?
Yes, Your Honor, we've completed the trial intervention. First,
Wayne Dylan Dean. State, the stipulation of evidence is, I guess supported, or just the only thing that is in here is the copy of the indictment. Is that your intention?
No, Your Honor.
And that's all that I have.
How do we rank the judge?
the police report. Thank you for the printer.
No, is it the best way?
So go ahead and have a seat and I'll call you back up. Here you go. Okay. Maybe any other counsel that's ready? Are you ready on Mr. Schmidt?
Estridge. I'm ready on a lot of them, I got announcements on all, but. I'm not on there yet, it should be.
Thank you, Mark.
Okay. I haven't seen her. That's the one we do first. Okay. Jeremy Estridge, CR 11-119. You are retained on that one.
Yes, sir.
All right, this is cause number CR 11-119, State versus Jeremy Wayne Estridge, set on a motion to revoke. Mr. Schmidt's understanding that you have been retained by Mr. Estridge and are not prepared for a hearing on the motion to revoke today. Is that correct?
That's correct.
Okay. All right, the court will enter Mr. Schmidt as counsel of record and will set Mr. Estridge for hearing. Mr. Schmidt, are you available on Tuesday, December 13th? And then what we'll do is we'll go ahead and set it for contested hearing in January. If there's no agreement on the 13th.
Yes, sir.
And that will be on January 26th.
Javier's is a thing.
Javier Zarate Junior, CR 21399. Mr. Zarate is set for pretrial today.
That's correct. We've done the discovery. We don't have any success future on motion. That's for not.
All right, court will set Mr. Zarate then for docket call. With the same date, December 13th. All right, court sets Mr. Zarate for docket call December 13th at 9 a.m. Mr. Zarate, I see that you're delinquent on your pretrial fees, $120. Have you made any payment towards those?
No, but I can make them today.
Okay, how much can you pay today?
I was 140.
Okay, all right. So once you're finished, just step across the hall and make a payment on those, okay?
Yes, sir.
You're free to go. Rollins. Jennifer Danielle Rollins, CR 22226. All right, Ms. Rollins is set for pretrial.
Judge, we're not ready for pretrial. We'd ask for an additional pretrial.
Is there an issue with discovery or?
No, Judge, this is an issue of coordination. Kind of.
Okay. All right, court will set Ms. Rollins then for docket call on December 13th at 9 a.m.
If you need pretrial.
I'm sorry, pretrial, yes. And Miss Rollins, I need you to hang on for just a moment. We may have an issue with our pretrial release. Miss Burns, the note that I have on my docket, is that present information?
Police, yes,
Is that from today?
no, I think it was from last week.
Ms. Rollins, just have a seat right over there in the jury box and we'll call you back up in a minute.
There's one.
Yeah, Mr. Schmidt. I'm following up. Who's your next one? Jonathan Curtis. CR 21-210, 2021 192. So we're set for docket call in each case.
That's correct, Judge. I think the court is where I took over for prior attorney.
Ms. Chester.
Yes, by the way, I have received this from the state. I believe we'll be able to resolve it eventually, but at this point, we're just not going to trial.
Go ahead and put it back on the jury trial docket.
Yes, sir.
All right, court will place Mr. Curtis back on the jury trial docket. Beginning Monday, December 5th. So Mr. Curtis, you've been on the jury selection docket before, haven't you? So you know that procedure, to be at the courthouse, 8:30, you'll check in. Okay. All right. So you'll do that same thing until your case is reached for trial. Okay.
All right.
Charles Bennett. CR 22-125, CR 22-238 for docket call.
Correct, Judge. We're gonna ask for an additional document call, still negotiating with the state on this case.
All right, court will set Mr. Bennett for a final docket call on December 13th. At 9 AM. And Mr. Bennett, I show that you're delinquent $200 on your pretrial release. Are you gonna be able to make a payment towards that today? How much can you pay today?
Don't pay it all. Just pay half.
Okay, you're gonna try to pay it all, but if you can, you'll at least pay half. Okay, as soon as you leave, I want you to step across the hall and make that payment. Christopher Nash. CR 21-388. Mr. Nash is set for docket call.
Same announcement, Judge, as for additional document call, Mr. Nash gives more opportunities to work with the state.
Did you sub in for another attorney on this one?
I believe I did.
Mr. Nash, you had prior counsel. Who was your attorney before Mr. Schmidt?
It's just.
Ms. Chester. All right, court will set Mr. Nash for a docket call on December 13th.
Still won't be here.
Yeah, that's a good question. Let me look for you. Yes, sir, we will be here.
David Dixon.
David Dixon. CR 22-269. Mr. Dixon set for pretrial.
Judge, we don't have any contested pretrial. I forgot.
All right, court finds that there's no contested pretrial motions. Court will set Mr. Dixon for docket call on December 13th at 9 AM. Right then. Jonathan Curtis.
That's a Jonathan Curtis.
Yeah. Bobby Evans. Well, he wasn't here, but yeah, I got people here, Noe Lamone, Josh, Gonzalez, Evans. The McClellans, I see if they do some door. Let's see, so that could be, you got Audrey English.
That's a.
That's a lot.
I think that's all.
Let's call it Cooksey and then put on the record that you have about her being ADR.
And I asked them to send a fax to Miss Taker to verify that early this morning, so.
CR 2293 State versus Savannah May Cooksey for docket call. Mr. Schmidt, you indicated you had information on Miss Cooksey.
That's correct, Judge. I had conversations with her early this morning. She was ill and heading to the ER. I asked her to provide the court as well as myself with documentation to that fact. I hope to get it this morning.
Okay. All right, court will recall her case at the end of the docket. See if we have that information. If not, then we'll I may consider doing a judgment not side under advisement. Otherwise, I may issue the judgment not side and then have a motion to withdraw it if it later we find out that she is in the hospital.
Yes, sir. Listen, thank you.
You ready, Mr. White?
Yes, I am, Your Honor.
Who are you ready on? Carlos Hernandez Jr., CR 22147. All right, Mr. Hernandez, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can put your hand down. All right, your name is Carlos Jerry Hernandez Jr., is that correct?
Yes, sir.
And Mr. Hernandez, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jeff White. Are you pleased with his representation of you?
Yes, sir.
Do you feel like you've had enough time to talk with him about your case and have all of your legal questions answered?
Yes, sir.
Is there anything about this paperwork that you've read over and signed today with Mr. White that you do not understand?
No, sir.
And where you have signed in this paperwork, you're telling me that that is your true and correct signature, and you only signed once you were confident in what you were signing.
Yes, sir.
Mr. White, do you believe Mr. Hernandez to be competent today?
He's competent today. He understood like this.
And you've explained to him his rights as they pertain to this case?
Yes, I have.
And do you believe that he understands them?
Absolutely.
All right, Mr. Hernandez, I see that you've been charged by indictment with a possession of controlled substance and penalty group 2 less than 1 gram, a state jail felony offense. Normally, a state jail felony offense would carry a range of punishment of not less than 6 months in prison to a maximum 2 years in prison and a fine not to exceed $10,000. I see that you have reached a plea in this case that you want the court to approve. And that is you would plead guilty to that offense in exchange for the state's recommendation that the prosecution proceed under section 1244B of the Texas Penal Code, which means that you would be prosecuted as a misdemeanor and punished as a misdemeanor at a class A misdemeanor at 2 days confinement in the county jail, with you receiving credit for 2 days of time served, paying a $2,000 fine, $180 restitution, and the court would be considering under section 1245 dismissing a possession of marijuana less than 2 ounces. In addition, you would have court costs of $270 and reimbursement fees of $35. Is that your understanding of the plea agreement?
Yes, sir.
And that's what you're asking the court to approve?
Yes, sir.
And would you, Mr. White, would your client be paying any of these financials that he owes today?
Yes, I believe he'll be paying 1/4. He's going to be paying about 1/4 today.
Okay, good. All right, Mr. Hernandez, understanding the range of punishment, understanding the plea agreement, do you wish to proceed?
Yes, sir.
All right, Mr. Hernandez, how do you plead to possession of a controlled substance, penalty group 2, less than 1 gram?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime and for no other reason?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty today?
Yes, sir.
All right, the court will accept the defendant's plea of guilt. Mr. White, any objection to states 1, the stipulation of evidence?
No objection.
States 1 is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further from the state, Your Honor. The rest of us.
Anything further from the defense, Mr. White?
Nothing, Your Honor.
All right, court will consider the evidence. All right, Mr. Hernandez, the court has reviewed the evidence. I do find sufficient evidence to convict you of this offense. The court will follow the plea agreement in your case. Court hereby convicts you of possession of a controlled substance in penalty group 2 less than 1 gram, class A misdemeanor under section 1244B of the Texas Penal Code. Court assesses your punishment at 2 days confinement in the county jail, awards you credit for 2 days of time served towards that sentence, orders you to pay a $2,000 fine, $180 restitution, $270 court costs, and $35 reimbursement fee. Court also dismisses under section 1245 DA 2022-208 a possession of marijuana less than 2 ounces. All right, Mr. Hernandez, you hereby remanded to the custody of the Van County Sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step forward in just a moment to be fingerprinted with Deputy Everett. It's very important that you discharge the financials that you owe. Your failure to do so will result in this court issuing a warrant for your arrest. Okay, step over here with Deputy Everett.
Do you want to read it?
We send it off for.
You want the results?
Ms. Payne, are you ready?
Yes, Your Honor.
All right, Mr. Dean, let's try it again. All right, Mr. Dean, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God?
Yes.
Okay, you can lower your hand. Your name is Wayne Dillon Dean.
Yes.
And Mr. Dean, are you a United States citizen who reads, writes, and speaks English?
Yes.
And in this case, you're represented by your attorney, Ms. Payne. Are you pleased with her representation of you?
Yes.
You feel like you've had enough time to talk with her about this case and have all of your legal questions answered?
Yes, sir.
Is there anything about this paperwork that you've read over and signed today that you do not understand?
No, sir.
All right, and Ms. Payne, do you believe that Mr. Dean is competent to enter into this plea agreement?
Yes, Your Honor.
And you've explained to him all of the terms and conditions of the pretrial intervention contract?
Yes, Your Honor.
And specifically, you've discussed with him the important waivers that he would be making with regards to his right to a jury trial, the right to expunction of all of his criminal records, and the right to a speedy trial.
Yes, Your Honor.
And do you believe that he understands all of those?
I do.
And Mr. Dean, do you understand that to enter into a pretrial intervention contract, there's several important rights that you would be waiving today? Do you understand that?
Yes.
You understand that the court approves this pretrial intervention contract and approves your waiver of a jury trial. If you violate this contract and you're brought back to court and you're put to trial, you will have waived your right to ask for a jury to come in here and determine whether you are guilty or not guilty. You understand that?
Yes.
And when you waive that right to a jury trial, you're also waiving your right to cross-examine the state's witnesses and confront their evidence in front of that jury. You understand that?
Yes.
And you understand that once you make this decision today, if I find that you're doing it intentionally, knowingly, voluntarily, meaning that you are your own free will and accord, that you're waiving your right to jury trial, it's unlikely that that right would be restored to you later, meaning you can't change your mind at a later date.
Yes, sir. I understand.
You understand that? In addition, you would be waiving your right to a speedy trial so that you could have time to enter into this contract and complete it. You understand that?
Yes.
And you also understand that if you successfully complete the program, your criminal records could be expunged, but not fully, only partially. You would be waiving your right to have the records of the DA's office and also the probation department that would be supervising you as part of this contract. You would be waiving the right to have your records expunged with those agencies. You understand that?
Yes.
Okay. And has anybody threatened you, Mr. Dean, forced you, pressured you to make you feel like you had to waive any of these rights that we discussed today?
No, sir.
Okay. And I see here that the pretrial intervention contract is for the charge of possession of a controlled substance and penalty group 2 less than 1 gram a state jail felony. If convicted and sentenced of that offense, you could be facing a minimum 6 months in prison to a maximum 2 years in prison and a fine not to exceed $10,000. Do you understand that?
Yes,
And this program, this contract, is for a period of 1 year. You understand that?
yes,
And you've read over the terms and conditions of the contract and you know what you're expected to comply with.
yes,
And you also know the consequences if you violate the contract.
yes.
Can you tell me in your own words, if you violate the contract, what would be the next step? Potentially.
Jail.
Well, you understand that you'd be brought back to court and you would have a right to a trial. It would be a bench trial. That means one without a jury, but with the judge making the decision on whether you're guilty or not guilty. You understand that?
Yes,
You understand that you've also agreed that there's certain pieces of evidence that would be admissible that may typically not be admissible in a trial. Meaning if a police officer were to come and testify at a jury trial, the reports that they bring may not be admissible in the evidence. But as part of this contract, you're telling the court that you agree that if you violate this and you're later put to trial by the court, that you're going to agree that their office reports and some other things are going to be able to be shown to the court. You understand that?
yes,
Okay. So you understand that when you violate the conditions of pretrial release, it may not result in jail immediately. You understand that?
yes, sir.
Okay. Understanding all of those things, you still wish to go forward?
Yes, sir.
Okay. All right, the court will find that Mr. Dean has been admonished as to the terms and conditions of the community of the pretrial intervention contract. Appears to have intentionally, knowingly, and voluntarily waived his right to a jury trial, a limited waiver of expunction, and also waiver of his right to a speedy trial. Court finds that he had done so with the assistance of counsel. And the court will hereby approve the pretrial intervention contract for a period of 1 year. All right, Mr. Dean, I'm gonna have you go with the probation officers and they'll tell you the next step. Officer Ventura, are you doing this?
Yes.
Officer Ventura will give you the next step, okay? Yes, thank you. You know what? I don't know if I signed that waiver of jury trial. It's which one's that is to go across. Ms. Burns, no, it's okay. Ms. Burns, will you text Rachel and make sure that I sign that waiver of jury trial? I think I did, but I'm not certain. So are you ready?
One more, Your Honor. Joseph Rushing.
Joseph Craig Rushing, CR 22156.
Your Honor, we're gonna ask for one more docket call on this situation. This case is a little bit complicated due to who was the arresting officer. And I don't believe the state has any oppositions to us setting up for one more docket call.
That's correct, Your Honor, and the state also made inquiries about some federal questions that I just got Mr. White the answer to this morning. And so I say it's going to agree to another step.
All right, court will set Mr. Rushing for a final docket call on. Do you want December 13th or 15th, Mr. White?
Which one's a Tuesday?
13th.
13th.
Thompson, are you ready? Tiffany Cooey, CR 22208. All right, Ms. Thompson, have you had an opportunity to review the email that Ms. Cooey provided to the court?
I have, Your
All
Honor.
right, and would you like to address any of the
Your Honor.
comments made?
Yes, sir, I would. As far as when a felony case gets indicted, that's when it's presented to the grand jury. Which this court is well aware that Bench Counsel has no control of when the grand jury meets or hears a situation being brought before it. I agree with her, it did take a while for it to get indicted, but it was a drug case, so I think that the wait on last for quite some time as well. Additional, every time Miss Cooey's been in court for misdemeanor cases, I've been right there. We have had several discussions. She's been indicted a lot longer than 4 months. She's been indicted since June of this year. She's had the opportunity to call me. She's called and asked and begged that I try to get the situation handled for her where she might not be facing prison. That was done, arrangements made for her. She refused to follow through with that. And this is where we are at this point.
All right. Ms. Cooey,
Yes, sir.
you want to respond at all?
I'm just ready to get this over with and so I can be back to my kids and stuff. That's all I want.
Understand, and you understand that Ms. Thompson doesn't have a magic wand.
I do, sir.
She can't go over to the state and make things happen. She can't go make the DPS lab testings faster. Part of cases in the criminal justice system is that it does take time to get through these things. And I understand that, as you said here in your email, that you're ready to get going in your life and have this quit hanging over your head. But you understand that Ms. Thompson is one piece of that puzzle, as is the court, as is the state, as is law enforcement. Do you believe that you can still work with Ms. Thompson in representing you? You've asked for court-appointed counsel. Ms. Thompson is on the court's court-appointed list. And I find no reason, based on what you said in your email and listening to Ms. Thompson's response, to believe that she has done anything that rises to the level of ineffective assistance of counsel or not paying attention to your case, unless there's something else that you think that you can tell me. Okay. All right, then the court's going to, if there was an official request to have Ms. Thompson removed, the court's going to deny that request, and we'll set Ms. Cooey for docket call. So my understanding, Ms. Cooey, through Ms. Thompson's announcement earlier, was that she's received all of the discovery from the state, and this is the felony case that you've been waiting on, correct?
Yes, sir.
She's received all the discovery. She's indicated to the court that there's no request for contested pretrial hearings, meaning no motion to suppress, no motion to quash indictments. And so the next step in this process is I would set you for a docket call, and that would be the time that you and the state have the opportunity to determine whether or not you are going to reach a plea agreement. And if not, then you'll indicate to the court that you want a trial, and I'll set you for a jury trial or a bench trial if y'all can't work it out. Okay. All right. So the court will reset Ms. Cooey for docket call. I'm resetting to December 13th and 15th. Ms. Thompson, I also have sooner. I have December 1st as well. I'm not sure what is better on your calendar.
50 would be good.
Okay, and that's going to be a Thursday, and we'll be over at the county court. So we'll be in the second floor of the courthouse when you come in. Okay. All right. So the court's going to set Ms. Cooey then for docket call on December 15th. And that will be at 9 a.m. Ms. Cooey, I show that you are delinquent on your pretrial release fees. Are you going to be able to make a payment towards those today?
$60.
How much?
$60.
Okay, have you already paid it? Or you gonna? Okay, so I order you to go ahead on your way out and make sure you get that paid. Okay, and then try to catch up on what you're delinquent.
Yes, sir.
Okay. All right. Once you sign the notice of setting and get your copy, then you're free to go.
Thank you.
All right. Let's see. Oh, yes. Oh, I see. I knew that I didn't. One of those afterthoughts. Sorry about that.
Don't I have one more, Ms. Chris?
Ms. Chris, yeah, CR 22-210 and 211. Ms. Abraham. Can you give us additional, you come up here and give Ms. Thompson additional information? You said that you had a text message from Miss Everett, I believe, over in the clerk's office that Miss Chris was reportedly in the hospital this morning.
Yes, Miss Chris had emailed me yesterday, said that she was throwing up. Wanted to know if she could appear by Zoom. I told her that she needed to appear this morning. Since then, and I think she's pregnant from what,
She did the, she did December the 13th.
so I believe she's in the hospital in labor and delivery, so
Mhm.
that's what the text from Miss Evans
Okay,
in Dallas Presbyterian.
okay. All right, court will reset. Miss Chris.
Previous to Ms. Chris's hospitalization, I believe that Ms. Thompson and I had an agreement to reset her to mid to late January. I believe we have an agreement for a plea. State is comfortable. I knew Ms. Chris was coming very close to the end of pregnancy. I have no doubt that this is legitimate. So state has no opposition to setting it out that far, Your Honor.
Okay. All right, so I'm gonna need Miss Chris to send in her documentation today from the hospital as the missing cord,
Yes, sir.
and we're gonna reset her to. Let's go, are you available Tuesday, January 24th?
It's part of this, I think so. Yeah.
Okay, all right, January 24th at 9 AM. That'll be for pretrial. Well, do you have any contested pretrial motions on her?
I do not.
Okay, well then we'll set her for docket call. I'll waive her appearance today at pretrial. But I would like to have documentation as to her.
I'll
hospitalization
go to get a hold of her, Your Honor.
You don't know. So she wasn't going to- right? Okay.
Well, I talked to her last week, and she understood where we're at. So.
And Ms. Thompson, I'm gonna give you this. Ms. Chris had a similar concern that Ms. Cooey did, so I'm gonna give you that and maybe y'all can get that resolved before January.
Okay.
Any update on Ms. Rollins?
Just leave.
She's clean. We'll wait for Mr. Schmidt, so.
Maybe it's your.
Yes, thank you, Ms. Thompson. Amber Lansdale. All right, so CR 17327. Ms. Lansdale, I see here that you're requesting to have your probationary period extended for an additional 7 months. That would extend you until June 13th, 2023. You're actually set to expire next week.
This way.
And so why are you asking the court to extend your probation?
I was given 390 community service hours. And I just wasn't able to complete it in time. My kids just came home after I got out. So I just got my kids back in years ago. I was working 2 jobs and I wasn't completing my hours, but I've already done 65 in the past month and plan to finish the rest out in the next month.
Okay. And is that all you lack on your probation?
I have a little under 100 left. Yes, sir.
Okay, good,
I've already got my fees are paid. I've done all my classes and everything.
good. Okay. And if I extend this, you believe that you'll be able to complete it?
Yes, sir.
Okay. All right, court will approve the amendment to the conditions of community supervision and will extend the community supervision period for Ms. Lansdale for an additional 7 months, now ending on June 13th, 2023. All right, Ms. Lansdale, Officer Mature is going to take that and she'll give you a sign. Okay. Mr. Schmidt, do you have a second on Ms. Rollins? She's going. Awesome. Don't want to bring it up. I'm gonna read it around and play it.
Yes, thank you.
Ms. Rollins. All right, Ms. Rollins, I had you drug tested again. I showed that at some point, maybe last month, you were drug tested in court and you were positive there for methamphetamine and THC. All right, and we sent that off. I've considered whether or not I should revoke your bail in this case and put you back in jail and just leave you sitting in the jail until you get your case resolved. Is that something you want me to do?
Yes,
Why not?
I have kids.
Okay. And are you any good to your kids if you're on marijuana and methamphetamine? You're not good for anybody, especially your kids. You understand that a violation of your conditions of pretrial release will, in almost all likelihood, land you back in jail, and you'll sit there until your case comes up for trial. And that means it may be 1.5 to 2 years before your case gets tried. That's a long time to be sitting in jail. That's a lot of birthdays and holidays that you'd be missing with your kids. Understand? I've tested you today. They told me that you're clean today, so that's good. I expect it to stay that way.
Yes, sir.
Understand?
Yes, sir.
All right, we'll see you back on December 13th. Ready, anybody?
Thank you, sir.
You're welcome. Audrey Andrews, CR 22237. All right, Ms. Andrews, your name is Audrey Rose Andrews, is that right?
Yes,
And Ms. Andrews, if you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, you can lower your hand.
Man, I forgot to point out that the DA's intention that states that this is to an information. It's actually a lesser included that was indicted. So I think the judge.
So it's to an indictment.
Yes, sir.
State, are y'all working on fixing the
I
judgment?
didn't, sort of information. I'm just saying.
Judge, I will fix it.
Is it just the first page?
Yes,
All right. Ms. Andrews, are you a United States citizen who reads, writes, and speaks English?
yes,
And have you ever been diagnosed with any type of mental condition?
No.
In this case, you're represented by your attorney, Mr. Schmidt. Are you pleased with his representation of you?
yes,
You feel like you've had enough time to talk with him about your case and have all your legal questions?
Yeah.
Is there anything about this paperwork that you've read over and signed today with Mr. Schmidt that you do not understand?
no, sir.
Mr. Schmidt, do you believe your client to be competent?
I do.
And you've explained to her her rights as they pertain to this case, and you believe she understands them?
I do.
All right, Ms. Andrews, it appears that you've been indicted with the felony offense of injury to a child, elderly, or disabled individual, a third-degree felony offense. However, the plea agreement today would be to a lesser included offense of a Class A misdemeanor. Assault causes bodily injury to family member. A Class A misdemeanor carries a range of punishment of jail time not to exceed 1 year and a fine not to exceed $4,000. Do you understand that range of punishment? I see the plea agreement that you want the court to approve is upon you pleading guilty that your punishment be assessed at 1 day confinement in the county jail, you receiving credit for 1 day of time already served, a $750 fine, $270 court cost, and $535 reimbursement fees to Van Zandt County. Is that your understanding of the plea agreement?
Yes, sir.
And if the court approves this today, would you be making any kind of payment towards any of your fees today? How much would you be paying?
Probably about 400.
400? Okay. All right, so Ms. Andrews, at this time, how do you plead to assault causes bodily injury of a family member, a Class A misdemeanor?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes,
Has anyone threatened you, forced you, pressured you to plead guilty?
No.
All right, the court will accept the defendant's plea of guilt. Mr. Schmidt, any objection to states one? States one is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, Your Honor, the state is in compliance. We've received an affidavit on prosecution from the victim in this case. It's Miss Andrews, ex-mother-in-law. It's a kind of a messy situation, but she's comfortable with our resolution to this, and we would ask the court to follow the plea agreement.
Anything further from the defense?
Not good.
All right, court's gonna review the evidence. All right, the court has reviewed the evidence. The court finds sufficient evidence to convict Ms. Andrews of this offense. The court will follow the plea agreement in this case. Court hereby convicts Audrey Rose Andrews of assault causes bodily injury of a family member, a class A misdemeanor. Assesses her punishment at 1 day confinement in the county jail, gives her credit for 1 day of time served. Orders her to pay a $750 fine, $535 reimbursement fees, and $270 court costs. Sure. All right, Ms. Andrews, you hereby remanded to the custody of the Van County Sheriff so and carry out the terms and conditions of the sentence. And have you step over to be fingerprinted with Deputy Everett. And the state, I'll need you to sign these plea papers whenever she's done.
I had one of them.
Well, I think that's together.
I mean, that's what I'm saying, teamwork, that's what's going to work.
It makes it. All right, leave more her. I mean, well, let's Andrew's off. Who's your playmaker?
Huh?
Who's your playmaker? Who you want? Who you want to be your playmaker? Here's Garrett Joslin. CR 22-149. All right, Mr. Schmidt, Mr. Joslin set for docket call.
He is, Judge. I don't know how many doctors we've had on Mr. Johnson, have been up and down on this. I would beg for another one, if the court would entertain it. I feel like we can resolve it. Feel like we can, but,
Let me look that up, and then in the meantime, I show that Mr. Joslin hasn't paid any on his pretrial release. I'll let y'all talk about that in just a second. Looks like today's the fourth docket call.
We'd ask for another one, John.
And tell me the reason for another docket call.
Well, Judge, the legitimate reason for another doc call is for me to have a chance to wear the state down and make him an offer that we can all be happy with. That's the legitimate reason. That's all I got. That is the legitimate reason.
I agree. What's the offer from the state?
Judge, while this is Mr. Woodwhite's case, while he's looking to see what his offer was, also there was a new charge, an additional charge that Mr. Johnson was arrested on, but we've never received a case. So I think there was a fair bit of waiting to see if we were going to receive a case on that. At this point, I think that's very unlikely.
The offer is 3 TDC of the 15 fines.
And how long has Mr. Joslin had that to consider?
One to change.
All right, let's do this. Mr. Waddell, will you drug test Mr. Joslin? He passes his drug test. I'll give him another docket call. He fails his drug test, no docket call, and he stays with me. Mr. Ashmore, you ready with Mr. Enochs? Or y'all still?
We're ready.
Come on up, Mr. Enochs.
Yes, sir.
It's been a minute. Thanks, Judge.
I thought to give Mr. Enochs my parking place.
Yeah, I know. And one Casey had to relieve the other Casey. I think her excuse was adequate, but
He always dresses better than me. That's what
I apologize.
makes me, yeah, he always makes me look bad. All right, this is cause number CR 21-324, State versus Chase Ray Enochs. Mr. Enochs, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today would be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
All right, you can lower your hand. All right, Mr. Enochs, are you a United States citizen who reads, writes, and speaks English?
I am, Your Honor.
And have you ever been diagnosed with any type of mental condition?
I have not.
And in this case, you're represented by your attorney, Mr. Casey Ashmore. Are you pleased with his representation of you?
I am.
Feel like you've had enough time to talk with him about your case and have all your legal questions answered?
Yes, sir.
Is there anything about this paperwork that you've read over and signed today that you do not understand?
No, sir.
All right, Mr. Ashmore, do you believe Mr. Enochs to be competent today?
I do, Your Honor.
And you've explained to him his rights as they pertain to this charge in this case, is that correct?
I have, Judge.
And do you believe that he understands them?
Yes, Judge.
And you've also talked to him about the advantages and disadvantages of a deferred adjudication plea?
Yes, Judge. We've discussed that the deferred gives him a one-time shot to get all his rights as a citizen back. And it also carries with it a very stiff punishment range should there be violations that result in a motion to adjudicate guilt. We've talked about what that looks like. And we're thinking about nothing but success, but he does understand those benefits and consequences.
All right. And so, Mr. Enochs, I see here that you're charged by indictment with the third-degree felony offense of stalking. A third-degree felony, if convicted and sentenced, carries a range of punishment of not less than 2 years or more than 10 years confinement in prison and a fine not to exceed $10,000. Do you understand that full range of punishment? And I see here that the plea agreement that you're asking the court to approve is for a finding of guilt to be deferred and you be placed on 5 years community supervision. That would be after pleading guilty to the offense. The court would fine you $750. You'd pay court costs of $290. You'd reimburse Van County $535. And the DA's office has agreed to ask the court to dismiss an assault causes bodily injury of a family member. That's the plea agreement. That's what you want the court to approve.
Yes, sir.
And you understand that if I approve this plea agreement, then you'll be placed on community supervision. And if you violate any of the terms and conditions of your community supervision, the state could file a motion to adjudicate your guilt. That means to convict you of the offense, could bring you back to court, could put on evidence of the ways that you have violated. And if they prove to the court that you did violate, the court could do a number of things, including the imposition of a sentence. The court could convict you, revoke your community supervision, impose sentence anywhere between that range of minimum 2 to maximum 10 years in prison. So it's a pretty serious range of punishment there. You understand that?
I do, Your Honor.
All right. So understanding all of those things, you still wish to go forward.
I do, Your Honor.
All right. So then the court will ask you, Mr. Enochs, how do you plead to the 3rd-degree felony offense of stalking?
Guilty, sir.
And you plead guilty to that offense because you are guilty of committing that offense.
I am.
And has anyone threatened you, forced you, or pressured you to plead guilty to this crime?
They have not, sir.
All right, court will accept the defendant's plea of guilt. Mr. Ashmore, any objection to state's evidence stipulation?
No.
All right, state's evidence and the stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, Your Honor. State is in compliance with victim notification. I think as the court is aware, the victim in this case is well aware of this case. However, we have not received the victim impact statement. So the state is in compliance.
Thank you, Mr. Woodwhite. Anything further from the defense, Mr. Ashmore?
My client would like to thank the court and the court staff. Is that permissible, Judge?
Absolutely.
I'd like to thank the bailiff, Mr. Waddell, Ms. Patty, yourself, everyone here for just treating me very, very kindly when you don't have to. And I've been here for a year. I've seen a lot of people come up here and plead, and nobody's ever said thank you for the way they were treated. So I want to say thank you for everybody before me and myself.
Good. Thank you, Mr. Enoch.
Yes, sir.
We do appreciate that. We do appreciate that. All right, the court has reviewed the evidence. I find sufficient evidence to convict Mr. Enochs of this offense. However, the court will follow the plea agreement in this case. The court hereby places Mr. Enochs on deferred community supervision, defers a finding of guilt, places him on a period of community supervision for 5 years, orders him to pay a $750 fine, $535 reimbursement fees, $290 court costs, and the court dismisses under section 1245 DA 2021-1151 assault causes bodily injury of a family member. Mr. Enoch, you hereby remanded to the custody of the Community Supervision Corrections Department so they can carry out the terms and conditions of the sentence. I'm gonna have you step over here with Deputy Everett to be fingerprinted.
Yes.
You put this under the, there you go, Rachel, I'm sorry. He is.
I'll be on the time. I think I may be excused till after afternoon docket, Judge.
Yeah, I think that's all you have this morning, right?
It is. I have one request. We're gonna try to do a waiver on Mr. Peters, which is my only this afternoon. I think today's agreement, so no.
Well, I can't do stuff for you, because I don't have a waiver agreement.
I thought you had it for him. Give me that.
You asked me for a waiver, that's the only waiver I have.
I was gonna say,
I haven't had enough coffee.
he said I have a
If you get your waiver of arraignment filed, you go, I don't know, we don't have one online, do we?
Well,
You
the
have
other
one?
thing, Judge,
I
is
think
that
he has one.
I may need to ask your permission to appear a little bit late. We have some clients coming to Cheryl. We need to sign some estate plan stuff so they can leave the country. Powers of attorney, things like that. And I may need to be there from 12:30 to 1:30 just to meet them. And
Well, I'm
then
saying if you want to go to jail now,
I'm gonna go to the jail now.
if you can get the waiver filled out, she's got a form. You can just let us know you've got that done. Let Patty know and
And
then
just Zoom or not appear.
not appear
Okay.
at all.
Thanks,
And then
Judge.
you want to mess with it.
Thank you.
Mhm.
All right. Probably gonna do that. On. You showed me there.
So Watson is on Zoom too, or not in the piece of the outcome, not here. I mean, I'm sure they're not.
You got 84% of the document. He knows what we got here, you know. So he's gonna be all right. He's gonna be clean. The other one was clean. She was dirty last time. I was kind of shocked at myself. I didn't even know what I was gonna say. I'm like, we're going home.
Was that?
Let me bring here, but getting deep into it.
That's what he says about.
Hang on a second. Let me do this. Mr. Watson. Where's Mr. Watson? There you are. Come on up. Come right up here in front of this computer over here. Do you see Mr. Platten there? Patty, can you go make Mr. Platten bigger so he can see? Morning, Mr. Platten. Can you see and hear me okay?
Yes, Judge, thank you.
Excellent. Okay. All right. This is cause number CR 18, 113 State versus Landon J. Watson. We're set on a motion to adjudicate today. Mr. Platt, I see that you have filed, have you filed a letter of appearance or notice of appearance?
I believe that was taken care of. Yes, Your Honor.
All right, the court will recognize Mr. Platten as attorney of record for Mr. Watson. This is, I believe, the first setting on the motion to adjudicate. What I would do, Mr. Platten, is I would reset Mr. Watson for, we'll just set him for basically a docket call type hearing in December. And then if there's no agreement, then we could set him for the contested hearing in late January. So if you have your calendar, will you look at either December 1st, 13th, or 15th? Let's see if one of those is better than another.
Let's look here. You said the 15th was your last one?
Yes.
15th looks like my best date, Your Honor.
Okay. All right. So what we'll do is we'll set him for a hearing on the motion to adjudicate, not a contested hearing, on December 15th. See kind of where we're at. And then if there's no agreement on that date, then we'll move forward to the January 26th contested docket.
Okay.
That would be in the morning at 9 a.m.
January 26th, if not the 15th. All right. Well, I will be there the 15th. Are you, do you want me to appear via Zoom on the 15th?
No, you can appear in person.
Okay. All right. Well, thank you for letting me show up this way today.
Yeah, absolutely. No problem. All right. So I'm going to fill out a notice of appearance, have Mr. Watson sign that, and he's going to be free to go.
Thanks, Judge.
All right. Thanks, sir. Appreciate it.
Bye.
You have a notice. So you fill out the list. All right, Mr. Watson, you'll come over here. All right, so you're gonna come back on December 15th. It's gonna be at 9 AM. And Mr. Platt will be here that day, so I'm gonna have you sign right there. I'm gonna give you a copy of this.
Yes.
All right, you're free to go.
Thank you.
Mr. Green, are you ready or y'all need time?
We're ready, sir.
Okay.
We're ready. We're just reprinting the first page, to make one minor change, and just make sure it's.
Okay, that's fine. We'll get that done. Mr. Dobbins, come on up.
I'm with Ms. Smith.
I know you are.
Oh, okay.
I was gonna wait for your paperwork.
Okay, that was a misdirection if I've ever heard one.
Can't wear shorts to court. I'm gonna let it slide today, but okay, when you come to court, you're gonna be wearing pants and appropriate shirt, okay? All right, Mr. Dobbins, this is the sanctions court hearing. All right, so I see here that last time we were in court, we talked about a lot of things, but we talked about what you need to do to get straight on your probation. I see here that you did pretty much everything I told you to do. You did 3 days in jail. I ordered you to pay $100 probation, $130 to collection. You came up about 50 cents short in each one of those. I'm not gonna hold that against you. You didn't work your community service.
Yes, I have the paper right here. They were supposed to email it yesterday. I completed my 10 hours like you wanted yesterday, and I got the paper right here where they signed off on it.
Okay, that's
They
good.
They were supposed to email it to the probation officer in Athens, and she was gonna send it over here.
Okay,
But
try-
the sheet right here.
that's fine. Well, you're gonna give that to your probation officer and they'll verify all that. Try to get that in earlier so that as we're getting ready for court, they can let me know that they've got that. Okay. I think you enrolled in your drug offender education class. That's good. All right, so I like what I see. All right,
Yes, sir.
so what I'm gonna do is, I'm gonna order you to come back, I'm gonna give you to January, but what you gotta do every month for me is that same thing. You gotta pay $100 to probation, $130 to court collections, and 10 hours community service. Okay, you're gonna have to do that every month until we can get you caught up. Okay,
Yes, sir.
and then you gotta complete that drug offender education class. All right, so keep on doing those things and that will keep you out of jail. All right, and that's what we want. We want you out of jail, doing what you're supposed to be doing. Now, give me an update on your CPS case over here.
I got to super my visitations instead of being at the office. Now they're supervised at the house where the grandmother has her grandmother has the child. So I get to go visit every Wednesday over there with the child at the house now instead of at the office.
Okay, good. Are you doing that?
Yes, sir.
You going to see the child?
Yeah, every Wednesday.
For how long?
In just an hour at a time.
It's a little girl, right?
It's a little boy.
Little boy.
Yes, sir.
How old?
2 months old.
2 months old.
Yes, sir.
Are you enjoying that?
Yes, sir.
You want to keep doing it?
Yes, sir.
All right, then you gotta do this.
Right.
You do this, that's your reward. Okay,
Yes, sir.
all right. All right, let's see, I'm gonna. That was so I'm not gonna make you come back in December. I'm gonna put it in. I'm gonna put it in January, okay?
Yes, sir.
All right, Mr. Dobbins, come up here. I wrote it down for you. I need you to do. Okay. All right, sign right here. It's gonna tell you that you're gonna come back on January 24th. Now you'll need to do all these for this month,
Yes, sir.
December.
Yep.
And it would be good to have all that done for January by January. If you're a little bit shy for January, obviously I'm not gonna hold that because there's another week there.
All
All right,
Okay.
so.
right.
But I'm looking for substantial compliance.
Yes, sir.
All right, so right here. I'm gonna give you a copy of that. All right, we'll see you back on January 24th, 9 AM. I don't know what court we're gonna be in, so if you don't know, call your probation officer. Oh, yeah, I'm sorry. I thought I've never done it. So I'm not sure where we're gonna be on January 24th. We may be back in our courtroom across the street. I don't know. If you don't know, just call probation officers and we'll get you figured out, okay?
All right. Thank you.
All right, you're welcome. All right, Mr. Green, Ms. Smith. This is cause number CR 21-341 and 2021-494, State versus Ashley Linnaeus. All right, Ms. Smith, if you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can lower your hand. All right, your name is Ashley Linnaeus Smith, is that right?
Yes.
And Ms. Smith, are you a United States citizen who reads, writes, and speaks English? And have you ever been diagnosed with any type of mental condition?
No.
And in this case, you're represented by your attorney, Mr. Green. Are you pleased with his representation? You feel like you've had enough time to talk with him about your case to the point where you've had all your legal questions answered? Is there anything about this paperwork that you've read over and signed today that you do not understand? You have to say.
Oh, I'm sorry. I'm sorry.
It's okay. I know you're a little nervous.
Stand up.
That's okay. My court reporter here is typing, so if you just shake your head, that
Right.
doesn't tell us yes or no, okay? All right, and so you are satisfied that you understand everything in this paperwork that you've read and signed, and you don't have any questions for the court or Mr. Green? Okay. Mr. Green, you believe Ms. Smith to be competent today?
She is.
And you explained to her her rights as they pertain to this case?
I have.
All right, Ms. Smith, I see here that the charge is a third-degree felony offense of driving while intoxicated, third or more. that does carry a range of punishment. If you were to be tried and convicted of that offense without a plea agreement, you could face the minimum 2 years in prison up to a maximum 10 years in prison and a fine of not more than $10,000. But I see today you want to enter into a plea agreement with the court in the state. Is that right?
Yes.
And in this plea agreement, it says that you're going to be pleading guilty to that offense of driving while intoxicated. The state's recommendation is that your sentence be assessed today at 4 years confinement in prison. But the state's recommending that that sentence be suspended and you be placed on 4 years community supervision. Part of the plea would be that you would pay a $1,000 fine plus restitution, court costs, reimbursement fees, and the state would also be dismissing a driving while license invalid case. Is that your understanding of the plea agreement? And that's what you're asking the court to approve today? All right, Ms. Smith, understanding the plea agreement, understanding the range of punishment for this offense, how do you plead to driving while intoxicated, third or more?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes.
Has anyone threatened you, forced you, or pressured you to plead guilty?
No.
The court will accept the defendant's plea of guilt. Mr. Green, any objection to the state's evidence?
No objection, Your Honor.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state,
No, Your Honor, we rest the cause at this time.
from the defense?
Judge, just would like the, and it is reflected in the judgment, but would also like the be reflected in the record that 90-day driver's license suspension is recommended by state in the judgment. And that is just so that it is reflected.
All right.
And Judge, I do believe it is. Mr. Green made that request. State has no objection to making that recommendation. It would so recommend for later proceedings regarding this driver's license. I don't believe this court orders that, but the DA's office would recommend 90 days suspension.
And so is that being communicated to DPS?
It'll be in the judgment. They'll review that, I believe.
Yes, Judge, that if it is not a period of time is not reflected in the judgment, then when it gets to DPS, it's an automatic maximum 2 years suspension. So
this is a reduced period.
that's correct, Judge, which 90 days is the minimum. But some period of time has to be reflected or DPS will suspend
For the maximum
period of time.
Okay. All right, court will, anything further from the defense?
No, Your Honor.
All right, the court's gonna review the evidence. Did you put hand sanitizer on? You didn't? It's not like that. You could lift his hand sanitizer. Yes, absolutely.
Today.
There's no fine listed there.
Oh, I'm sorry, Judge. I just missed that.
Okay, just want to make sure it's right there in case there's a question later.
There was a restitution amount too. I just.
You like me? Further back the better.
Got it.
Further back the better. And Ms. Smith, you've gone over the conditions of probation, is that correct? All right, you're gonna need to sign those when you get with the probation officer. So, all right, Ms. Smith, I've reviewed the evidence. I do find that there is sufficient evidence to convict you of this offense. The court will follow the plea agreement you've reached in your case. Court will convict you of driving while intoxicated, third or more, a third-degree felony. Court assesses your punishment at 4 years confinement in the Texas Department of Criminal Justice. The court suspends the sentence today, places you on 4 years community supervision, orders you to pay a $1,000 fine, $290 court costs, $60 restitution, $35 reimbursement fees. And the court does dismiss a driving while license invalid DA 2020-434. All right, prior to me having you be fingerprinted by Deputy Everett, I want to talk about this for a second. So this is your third DWI. Okay. And today you've become a convicted felon. So what's your plan going forward on how not to drink and drive?
Well, I haven't drank in 6 months, so I have a breathalyzer and it's actually been beneficial.
You know, some people come in here and they get convicted for driving while intoxicated and they see it as a negative thing. People like you in your situation where they get pulled over because they didn't use their turn signal or they were speeding, caught the attention of a police officer, get pulled over, go to jail, get arrested, end up in court, get convicted, go on probation. Some people see that as a negative. Me, on the other hand, for someone like you, I see it as a positive because very well that these officers could have saved your life or the life of anyone else that you were passing that night. You were over 2 times the legal limit, over 2 times. So you definitely don't have your mental and physical faculties when you're 2 times over the legal limit. So you can choose to walk out of here and view probation as a negative thing, or you can view it as a chance to say, you know what, I had intervention in my life that night. I'm walking out of here, physically walking out of here. And I'm not walking out of here worried about someone that I killed or going to prison or killing someone in your car, things of that nature. Okay, so perspective is huge, I believe. Okay, so my recommendation is that you go over and you be accountable, responsible, and you work hard on probation. And if you got a drinking problem, now's the time to get your help. They're not going to give you that help in TDC.
Right.
There's classes you can take, but you're not going to get the therapeutic treatment hands-on that you're going to need. So if you're a social drinker that can't handle social drinking, then don't be a drinker at all. Okay, don't risk your life, my kids' lives, all of us that live in this community. Don't risk it. All right, because if you violate the terms and conditions of your community supervision, you drink alcohol, even if you celebrate on New Year's with a glass of alcohol, that will send you to prison. I promise you, because I'm not going to have any tolerance for alcohol, drugs, or anything like that while you're on this probation. Okay.
Mhm.
All right, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. Now, if you step over here with Deputy Everett, get your fingerprint, and then you'll go with probation.
Judge, if I might add one thing. We took into consideration a Class B driving with a license invalid. There's also a Class C open container. State will be dismissing that. I just don't have the paperwork yet. But I do want to put on the record for Ms. Smith's information. We will be moving to dismiss that today. I just don't have it with me right now. I'll bring that to the court.
Okay, noted for the record.
Thank you.
Mr. Green,
Yes, sir.
can I see for a second?
Yes.
Do me a favor today. If you were sending in to arraign a defendant on Mr. Manning, he's not here. We have Penny Richard, he's conflicted. Would you arrange him for me?
Right now?
And then Billy. Yeah.
Yeah.
You do it for me?
Yeah.
I've had to get you the indictment and I'll explain to Mr. Young what I'm asking you to do.
Okay.
Just then,
Okay. Yeah, I'll do that.
Let Patty know she's in the back. Just let her know you're gonna do it.
Okay.
How are we doing? When you have dates?
Yes, sir. But I just sent you a notice for Miss Grace. You're gonna sit. Abraham.
Oh, here it is.
Brittany. She said with the symptom, she is in the hospital. She's sitting.
Yeah, they told me that that she's in labor, right? She's in labor delivery.
They're induced with the symptom.
Oh,
And the baby will have to go. So. In the status.
okay. Yeah, thank you for that. I appreciate it. She may have stepped across to make a copy of that amended appointment. As soon as she gets back, let me call her real quick. Okay. Get you out of here. Mr. Abraham. Mr. Green, I've asked Mr. Green if he would stand in for arraignment purposes for Mr. Young. Will you get him a copy of that indictment? He's gonna do that for me. It's Young, correct? Is that right, Mr. Schmidt? Young, maybe Young.
Yes, sir.
Yeah, so Mr. Young, this is Mr. Steve Green. He's a licensed attorney here in Texas. Mr. Young, I'm not appointing, Mr. Green is not a court appointed attorney in this court. Mr. Manning is, and he's not here at this time. But what I've done is I've asked Mr. Green if he would assist the court today and you in getting you arraigned today so that we can get you scheduled and out of here. And Mr. Green's going to stand in just for the purposes of making sure that you're the person identified, that you understand what you're being charged with, okay? All right, thank you, Mr. Green. Are you ready, Mr. Green?
Yes, we're ready.
All right, come on, Mr. Young. All right, this is cause number CR 22-349 State versus Randy Leonard Young. And the court finds Mr. Young is set for arraignment today. The court has found Mr. Young to be indigent, has appointed counsel. The court has appointed the Honorable Jonathan Manning. Mr. Manning is not present in court today. The court has asked Honorable Steve Green to stand in the purposes of arraignment. Mr. Green has done that for the court. And so, Mr. Green, any announcements for Mr. Young?
Judge, previously to visit with Mr. Young, I was provided a copy of the indictment. In this case, I've visited with Mr. Young about that indictment. He's indicated that his name is spelled correctly, that he understands what he's accused of, with waive the reading of that indictment, and then our plea of not guilty.
Thank you, sir. All right, the court will find that Mr. Young has waived the formal requirements of arraignment. The court will enter his plea of not guilty into the record. And the court will set, I got a notice setting. Court will set Mr. Young, thank you, Mr. Green. Court will set Mr. Young for a pretrial hearing, and Mr. Manning will be present on that day. Court will set this on December 15th. Do you know if Mr. Manning has any schedule, any vacation letters or anything? On the 15th, already? All right. All right. All right, Mr. Young, if you'll come up here. I'm gonna have you sign right here. This is just a notice of appearance, and then we're gonna come back for pre-trial hearing. Mr. Manning's been appointed. Might be come back on December 15th. We're gonna be over in the county court, which is in the courthouse that day. This is today's date. You'll show up on the 12/15 at 9 a.m. Okay? All right, so you're gonna sign it right there on the X, and I'm gonna give you a copy.
And Judge, for the court's information, we've already sent online discovery to Mr. Green.
Thank you, Mr. Woodward. All right, and Miss Abraham has shown you where the contact information is for Mr. Manning. Yes, sir. Okay. All right, be in contact with him in the next couple of days. Okay. All right. Thank you, sir. Thank you, Mr. Green.
Yeah.
Hey, do you want to take a picture of that and then
Send it to John.
no, you take no. We'll send a copy to Jonathan. I'm saying you can take a picture of that and you can build it if it's called.
So I just, there's a particular form.
It's not that.
I don't know if I-
We'll email you. It's just a flat sheet. Yeah.
Okay.
Thank you, sir. Appreciate your help.
Yeah, no problem.
All right, Mr. Schmidt. Are you ready on anyone other than Mr. Joslin?
I think that's all I have, bro.
Have you seen the results? All right, Mr. Joslin, come on up. All right, this is cause number CR 22149, State versus Garrett Lee Joslin. I believe the request from the defense was to set for an additional docket call for Mr. Joslin. Court's going to grant that request. Previously, I told counsel and the defendant that depending on Mr. Joslin's drug test results, that if he failed his drug test, that the court would deny the request for docket call, would put him in custody. The court is going to grant the request for an additional docket call. We're going to set that on December 13th at 9 a.m. That'll be in this courtroom, Mr. Schmidt. Court's going to find that Mr. Joslin has violated the conditions of pretrial release by admitting to smoking marijuana just yesterday. And that Mr. Joslin knows that that's a violation of the court's conditions of pretrial release. The court's going to find his bail to be insufficient. And I'm going to order Mr. Joslin into custody.
Where's your check? Probably right here. Yes. Yeah. Yes. Yeah, he's got a shoulder. We don't know. This is a big one. Yeah. Some city. Yeah.
I haven't yet. I usually double it. Do you know what it is? Here, I can find it. I'll just double it.
Yeah, I just got the, she, I don't think to pass it to you, pass as well, but I don't know the.
Well, Amy could call and say that she was in the hospital. And then I got an armband on Chris.
Hey, it's ever ready for us. So I have them in custody and have the family. Yes. 4331501. Just. Could be a Gary job. It's 5181 is my meeting. Perfect. Can we let Joe know? Can we let Joe know? Bring him over? Perfect, thank you. I'm gonna go once it gets right shade.
Are you putting them over there?
You know, be over there. Sorry, one of them.
Human trafficking, that's one. Motion. Human trafficking. Legal one. When I saw that or what? First time? I started right there. Ooh.
It's even it's out there and I see happening through it.
All right, the court has called the following names loudly distinctly 3 times in the courthouse annex and also in the courthouse, and no response has been received, and the court will be issuing judgment nisi and alias capias. Robert Daniel Lopez, Randy Lee Shane McElroy, Motswana Malone Malongo, Bobby Lynn Evans, Noe Ramon. So those names have been called and the court is issuing judgment nisi and alias capias. Court's going to stand in recess until 1:30.